The Ohio criminal court system. These are the basic steps of what a person accused of a crime goes through in the Ohio criminal justice court system from the offender's initial arrest until their sentencing. This video is a brief overview and not legal advice. We recommend that any questions you have regarding your criminal court case or the case of someone you are seeking information for should be directed to your court-appointed lawyer or a lawyer whose services that you are paying for. Now, let's go through each step in the process. The crime. In order for someone to first enter the Ohio criminal court system, they must first be accused of a crime. The individual doesn't necessarily have to have committed a crime. The arresting law enforcement agency just must have a reasonable suspicion that the person arrested was the offender. The arrest. An arrest is the act of apprehending and taking a person into custody, meaning to capture and detain them in an Ohio city or county jail until further information about the crime can be gathered and decisions about the next steps and the legal process can be made. The arrest can also be due to a warrant being issued. Booking. The arrested is taken to a police station and booked. Booking includes having your photo and fingerprints taken, as well as being asked a lot of questions about what happened that lead to the arrest, your personal history, and state of mind. An investigation is started immediately into your criminal history, evidence, or witnesses. Most Ohio licensed attorneys will recommend at this point that you remain silent and do not offer any information because you can count on anything you do say will be used against you. When allowed to make your one call, it is best to call a reliable family member or an attorney because they will know where and how to communicate with you and can communicate on your behalf. Bond companies and attorneys do not always take collect calls, which is the only way the arrested can call. It is not advisable to call a friend, dating partner, or anyone involved in the crime. Detained. The moment the decision has been made to detain you in the jail, your rights become much more limited. If you have not already made your one call, you can make it in detention. Use this time to understand the charges against you and your next steps, whether it includes bail or a court appearance. Though difficult, it is the time to stay patient. The next steps vary, depending on the type of crime, the severity of the crime, and location where the crime occurred. Hearings and appearances. For the arrested to have due process in Ohio, which is the right to fair treatment through the normal judicial system, hearings and appearances are held up to the time of either release or trial. Examples of important hearings include the initial appearance, also called the first appearance, arraignment, preliminary hearing, and bail hearing. The arrested will be told when and where to appear at the hearings by the arresting officer, jail, attorney, or court. The notice might be on paper without being told in person. It is up to the court to decide whether the hearings are held in person in a courtroom, by telephone, or video conferencing. Initial appearance, also called first appearance, is the first time that the arrested will appear before a judge. The initial appearance occurs within 24 to 48 hours with exceptions if the arrested is in jail, and possibly longer if the arrested is out of jail on bail. At the initial appearance, the judge in the state of Ohio reviews the information from the police report as the arrested person's name, address, and alleged crime committed. The judge then informs the arrested of the allegations against the arrested. The judge can release the arrested if the evidence against the arrested is weak, but if sufficient evidence exists, bail is set. If bail had been previously set, the judge can reconsider setting a new bail. The judge also tells the arrested about the right to remain silent and the right to have an attorney. The initial appearance is not the time that the defendant states the plea, whether they are guilty or not, and if asked questions, the answers should be yes or no. There is an exception to not stating a plea at the initial appearance because sometimes the initial appearance might be the only appearance for less serious misdemeanors. The arraignment. Arraignment can be an initial appearance if it is the first time a defendant sees a judge in their case. It is typically the first time also for defendants who are not arrested but served with a summons or citation. If the defendant does not have a lawyer, the court can appoint a lawyer for them. If bail has not yet been set, it's addressed at the arraignment court hearing, and if requested, the bail can be reviewed by the judge and changed or kept the same. Some arraignments are similar to a first appearance when the bail, rights, and allegations are introduced. The judge will ask the defendant whether they understand the criminal charges against them. This is not the time to argue or say anything. Yes or no should be the only response. Some arraignments are more formal due to the formal charges produced by the prosecutor or the grand jury. The defendant may be requested to plea. In this more formal arraignment, the defendant is given a copy of the formal criminal charges filed with the court. After the judge informs the defendant of their rights, the defendant or their lawyer will enter a plea to the charges. There are 3 plea options. The defendant can say that they are guilty, or not guilty, or no contest, meaning that they are not contesting the charges yet or not admitting guilt. Preliminary hearing. The preliminary hearing is only held if the defendant said that they were not guilty during the arraignment or initial court hearing, and usually within 30 days. Think of it as a screening process to gather evidence, witness reports, and the incident reports to determine whether the case should go to trial. In some cases, the judge might decide that the defendant is not guilty, and the charge is dismissed, meaning that the bail money will be returned, minus court fees, and the defendant is free to go home. The defendant can decline the preliminary hearing and go to jail and await trial. Some preliminary hearings are held by video conferencing. Pretrial proceedings. Pretrial proceedings start after the arraignment and include back and forth communication between the attorneys and the court in preparation for trial. Proceedings can include discovery requests, pretrial motions, or a pretrial conference. Discovery is the process where both sides, prosecution and defense, gather information, interview witnesses, request records, videos, and analyze evidence. Both sides must share the information that they have gathered. This information does not include conversations between the arrested and their attorney. Pretrial motions are formal requests for some kind of action by the court. For example, there are motions to suppress, meaning holding back unfair information. Motions for a continuance, meaning to delay the trial for a variety of reasons. Motion to dismiss, meaning to drop a charge. Or motions for discovery request. A pretrial conference is a meeting between the attorneys on both sides and the judge assigned to the case. Subjects discussed at the conferences include available discovery material, what evidence or witnesses are allowed to testify at trial, dates of trial, or unusual circumstances that might need to be addressed. Pretrial conferences are held either in person or by video conferencing. Most pretrial proceedings do not require a defendant's appearance. This is the time that a settlement called plea bargain is discussed between the parties. Plea deal. Most cases do not go to trial because both sides reach a plea deal, or both sides try to reach a reasonable punishment based on what was learned in the pretrial proceedings. A plea deal can only happen if the accused person admits they are guilty in exchange for a lighter punishment. The reason they must admit guilt is because it would not be fair to punish someone who claims they are not guilty. If a plea deal is not reached, the case then goes to trial. Trial. Trial is where both sides in an Ohio court share their information in front of a judge or a jury. There is a set order and rules to how the information is presented, and the judge makes sure that the rules are followed. In a criminal trial, the prosecuting attorney presents evidence and witness testimony to try to prove beyond a reasonable doubt that the defendant committed the crime. The defendant's attorney presents evidence and witnesses to show that the defendant did not commit the crime. After listening to all the evidence, the judge or jury decides the verdict, which is whether the person is guilty or not guilty. If a jury is selected, it is called a jury trial. If a court has only a judge hearing both sides, it is called a bench trial. If the defendant is found not guilty, they are acquitted because there was not enough evidence against them, and they are soon released from jail or bail conditions. If they are found to be guilty, the next step is sentencing. Sentencing. Sentencing is the punishment that the judge decides the person should get. Judges use sentencing guidelines written by Ohio to suggest fair punishment for the crime. Sentences can include a combination of jail or prison time, probation, fines, restitution, damages, and other conditions. Probation can be also required after jail or prison time is served, or instead of incarceration. It allows the defendant to return to the community under specific rules or conditions such as restriction of who or where the defendant can visit, possible ankle bracelet monitoring, reporting to a treatment center or parole officer. If a sentence is considered severe, the defendant's attorney can ask for an appeal. It is important that you ask questions of your attorney and understand the steps throughout the Ohio court process.